Counsel Cunningham here.
Your Honor, it's my understanding that Mr. Cunningham is representing himself, and as this is the start of a new proceeding, the people just ask that the defendant be advised of his rights to representation.
I'm advised on my rights to representation right now. I'm waiting for the subpoena to come back. So I was asking the court for a adjournment until the 31st or a little bit after the 31st of May, considering the subpoena has not came back and nobody has not contacted me since I put the subpoena in. If y'all need a reference of basically when the subpoena was sent out, that would be, I can send that to you. And then also, as far as the original witness is not on the witness list, the accuser, quote unquote. And then also, Your Honor, I was supposed to ask for a motion for the case in whole with the videotapes and the transcripts, which still has not been sent out to me. So I'm also waiting for that as well, Your Honor.
Well, he sure started this court hearing out the same way he started the last one, saying a bunch of nothing.
Mr. Cunningham, it's generally considered to be a very bad idea to represent yourself. I want to advise you that if you do choose to represent yourself, that you're held to the same standards as an attorney. And as you know, attorneys go to school for years to learn how to do what they do. I won't be able to help you to
practice law, ma'am. You
represent
don't need,
yourself
you don't
or
need
to follow the rules.
to practice law. You don't need to be a part of the bar association. Sorry, I already looked that up. Unless Mr. Lou Dang can show me a license, and I'm not talking about a bar license as well, I would dearly appreciate that as well. But yes, I rather represent myself, man.
Yeah, you rather represent yourself because, quite frankly, you're an idiot.
Okay.
If you want to show me a license,
what kind of
we can go all day. Actually, I'm talking about the practice law, ma'am. I'm talking about the practice law. There's you don't have to have a license to practice law. I mean, this is not the first time I've been in front of you.
I know that, sir. You said that you wanted to see a copy of Mr. Danner's
license. Okay, well, you just kind of. I mean, I'm not taking it as a threat or anything, but you just stated because he went to law school or whatever, that basically I still don't know my rights, man. So one of my rights I'm asking is basically, yes, ma'am.
I'm required by law to advise you that it's a bad idea for you to represent yourself. I'm not doing it to
so is that
threaten you or intimidate you or scare you or anything else. I'm doing it because I'm required to.
Well, ma'am, I'm gonna ask this question then, ma'am. Is that advisement privately or commercially, ma'am? Is that advisement privately or commercially, ma'am?
Sir, what in the doohickey are you talking about?
Is that advisement privately or commercially? Are you advising me commercially or privately? You just stated it, advising.
I'm advising you on the record.
Basically get attorney. Man.
I'm advising you on the record.
So would that be privately? Would that be commercially, ma'am?
It's neither. It's on the record.
How is it neither on the record when basically it's a you're not my attorney, so how can you advise me to do anything?
There are lots of things.
It's a question, ma'am. It's a question, ma'am. I'm just asking, how can you advise me to do anything unless you're a representative, unless you some type of representative, have some type of contract with the Cunningham party? Let me know, ma'am. And that's other than that, you're an arbitrator.
Mr. Cunningham, every time that you appear in front of me when you're representing yourself, I'm going to give you the same advice, which is that you would be better served by having an attorney. I have to do that.
Such as the last three judges, ma'am.
Excuse me, sir.
Sir, ahead,
give me a minute to talk. Every time you appear in front of me representing yourself, I'm going to advise you again that it's a bad idea. I'm going to advise you again that you'll be held to the same standard as an attorney. And I'm required to do that. If it becomes a problem for you that I advise you that you'd be better served by having an attorney, then we're not going to get along very well, sir. I'm doing what I am required to do by law, which is to advise you on the record that you would be better served by having an attorney. And I'm telling you right now, I'm going to do it every time that you appear.
I mean, I just don't get it. What part of what she's saying doesn't this fool understand? She's not advising you that you're better off being represented by an attorney because she's your friend. She's literally doing it because it's her job to do so. Now, whether you listen to her advice, that's on you, but just listen to what she's saying and move on.
Well, to get along, first of all, to get along and be in basically correct court proceedings and facts will be two different things, man. So to get along,
I didn't ask you anything,
it
sir.
sounded like a threat. Excuse me.
I did not ask you any
I just
questions.
listened to what you had to say, man. You cutting me off. I just went through
Mr.
this
Cunningham?
with Ms. Perry, man. I was only stating my claim, man. I thought it was my turn to talk. If it's not my turn to talk, just let me know. I thought it was my turn to talk. If it's not, just let me know. But I thought it was my turn to talk. You just interrupted me.
What do you want to say to me, sir?
I just said what I was saying. I was trying to get a adjournment until May 31st until basically I get the information back from the subpoenas. And I'm asking basically Lou Dang, the attorney, to actually have the original witness, Calvin Kleinoff, on his witness list, man. That's all I'm asking. Other than that, I'm not asking anything else.
Your Honor,
Yes.
two things. First, if Mr. Cunningham would like an adjournment of this matter, I have no objection to Mr. Cunningham receiving an adjournment of this matter whatsoever. Secondly, the people are under no obligation whatsoever unless this matter is set for trial to produce any witness unless there is an evidentiary hearing in which there's a motion that is filed for an evidentiary hearing requesting the admission of an individual party who will be considered a res gestae witness to this matter. As there has been no articulation as such, and as Magistrate Garwood is not a party to the case, and also since Officer Kavanaugh, I believe in this case, would only be the officer who swore out the information, or in this case, or the complaint. In this case, that Mr. Cunningham, would you mind 1 second, sir? Would you mind 1 second? Thank you, sir. So, Your Honor, if Mr. Cunningham wants a trial to be able to exercise the court's authority of subpoena, then he can request a trial date and then try to have that occur. Or he can file the proper motion, as I am in receipt of a motion that is not the proper motion to be filed, nor is the relief that he is seeking such relief that this court would have the authority to grant. So it is my understanding that even if he wanted the adjournment or whatever subpoenas to go out or anything of that nature, that would be a non-starter, as that is not what would occur, as none of this was properly done according to the court rules or case law. So, but if he does want a trial, or if he wants, he can request a trial, and then he would be able to subpoena witnesses to be there to testify at a trial, as the court would fully advise him of that right. Beyond that, Your Honor, I am not in receipt of any intelligible motion in which he has stated any kind of claim in which this court could grant any relief.
Okay, we'll adjourn to May 31.
Excuse me, ma'am. I wasn't done talking, ma'am. If you look at first the document A1 basically sent to the Cunningham party, what was it? October 26, 2020. Basically, you look at A1 evidence. The states on there, Ryan Kavanaugh. He's not an officer. It just states original witness. Now, the original witness, basically, what we haven't had an motion for is basically for the head of the case. I can't think of his name. Matthews. That basically, quote unquote, they tried to amend in that him to be the original witness, when basically the original witness was actually Ryan Kavanaugh, who basically is not a complainant officer, is not a officer.
What? Bro, what are you talking about, man?
He was a regular civilian on the road that basically they try to put in after the fact that basically I was not supposed to be on U of M territory, and then they searched my property, and then from there they try to add in Mr. Matthews as the original witness, when basically he cannot be the original witness if he's in charge of the case. That's kind of like a contradiction. And then at the same point in time, he did not sign up under a penalty of perjury as well. So, I mean, I'm confused here, man.
No shit.
at this point in time. But I will take the adjournment to May 30, a little bit after May 31st to find out if I can get the rest of my my subpoena to go further and more than that. So if we can go to subpoena 31st, from there, excuse me, my motion for a subpoena from there, I would gladly enlighten you about this case.
All right, were you asking for May 31st or another date?
I was asking just a little bit after May 31st will be much appealing over on my side, ma'am.